see. Hangout is on there live. Okay, we are back live, and I'm with Jay again, and we're going to talk about dissecting traffic court and beating a case with driving with an invalid license. Now, I have actually gone to court on this several times. I have won in Dallas County on it. I've also won in Lake Dallas on this. Fighting them, I actually beat them with their own laws using the Brady list. That's also on the website. And y'all be sure and give this a thumbs up and subscribe to the channel. But so anyhow, what we're learning here is how to assert your rights. And this is the big misnomer. Everybody goes in as a defendant, and you have to get that out of your head. Well, a lot of the old patriot nut people that a lot of people complain about are using all these different types of stuff, and you know, you hear a lot of bad stuff, and then you get labeled all these things, sovereign, and all this other stuff. We're not doing all that. We're taking the law, their law, and using that law against them, beating them over the head with their own law because they're violating their own policy and procedure. And that's the part that y'all don't understand yet, is they are supposed to follow policy and procedure. They have a certain way of doing things. They have an oath that they took to do that. When they don't do that, they breach their fiduciary duties. They're getting paid to violate your rights, and you don't even know it because you don't understand it. So what we're going to do is break this down a little bit and show y'all how, like, or in my case, when I got pulled over, and these are situations that I've done and the outcomes of that, and Jay's going to clarify the law and what is the actual policy, procedures, and steps that should have occurred. So with that, let me just go ahead and say Jay is a good friend of mine. He is a very smart person. Once y'all get to know him, y'all will understand what I'm talking about. So when I got pulled over with by the cops in Rockwall, I had left a court trial that was a trial by jury and was found guilty. But I was going to appeal it, and the judge knew very well I was going to appeal it because of all the paperwork I've turned in before. And all the paperwork was subject matter jurisdiction, challenging all that and everything like that. Well, I didn't really have a full understanding of subject matter jurisdiction at the time as well as I did. I just knew that there was a challenge there, and the way to express it comes with a little bit of a learning curve. So what occurred is when they pulled me over, the judge had me arrested after trial, right when I was about to get on the highway, before I could actually leave town, and arrested and thrown in jail. 4 hours later, I was bonded out, you know, and I'm done, going home again. So, but in that, the cops had zero authority because they didn't have a warrant. I actually produced a document, a right to travel document for him at the time, which he completely ignored. And that video is actually online. I haven't gotten their video yet, soon coming. But anyhow, the cops didn't have a warrant, and they took me directly to jail. They already had a bond posted, and all I had to do was pay the bond, get out of jail, and then, you know, get a court date. So with that, they violated several steps here, and with that, Jay can expand on absent a Fourth Amendment warrant. So with that, let's bring Jay in, and why don't you tell us about a Fourth Amendment warrant and process?
Okay, folks, it's guaranteed to you that the government, right now we're talking about the Bill of Rights. There's only 10 of them. You don't have to worry about one of them because so far they haven't quartered any troops in your home, and that's the Third Amendment. So let's forget about that. You have the right to speak, you have the right of religion, you have the right to assemble. You have all these rights. You got them. You also have protection and limitations. All these that we are told are our rights are constitutional limitation on the application of state police power. They can't exercise the police power of the state unless they're in absolute conformity with the 10 rules, the Bill of Rights, actually government limitations. They swore they would not do these things. They swore that under no circumstances would any of us have to worry about it. The Fourth Amendment is called the Security Clause. You're to be safe in your person, that's your body, your place, that's wherever you are, and your things. Whatever it is that you possess that's yours, they have to have a reasonable cause to suspect that you have done something. They have to be able to describe you relatively well. They have to describe the place that they're going to be searching, and they have to explain exactly what they're looking for. It's not a fishing trip. Before that, there has to be a complaint filed. That complaint of what you did wrong has to be followed by an affidavit signed under penalty of perjury. Why that? Because if the claim is false, they suffer no damage. They impugned your reputation. They impugned your family. They did everything, and they suffer no penalty because, well, it wasn't true. But under penalty of perjury, the mere fact that they lied on a court document in the public, on record, signed, that swears they're telling the truth, they're qualified for 10 years in the pen now for perjury. So that gives the person that's being accused a sense of relief because they can't get away with just making up false claims. But
Well,
they can unless you bring it to them.
Well, now we're getting into the jurisdiction and due process. So let's just go ahead and establish jurisdiction and how when an officer brings a bogus claim into court and the prosecutor takes and uses this instrument on it's irregular on its face and presents this to a judge. Go ahead and explain that to people real quick.
Okay. They bring, the police officer writes up a complaint against you. Traffic, it's called a citation. Everybody's seen one. Okay. That is a valid document if you happen to be engaged in commerce. I didn't say business. I didn't say life. I said commerce. Now, you'll have to look that up in a law dictionary because it's a complex definition. If you understand it, you'll know that you're not doing it. You don't trade in bills and negotiable instruments. And that's what commerce is, the hauling, the transportation, and the financing of what was hauled and the payment thereof. That's got nothing to do with us. We are merely going to the grocery store, picking up the kids, going out on a date, the necessities of life. Now, they're not under strict regulation by the government because they can't determine what's necessary for your life. You may need a 4K 62-inch screen to be complete in your life, and according to you, that is a necessity. So you'll do everything you can to purchase one, and once you've purchased it, it's yours. It doesn't make any difference whose money you use to purchase it. You did the work, you sweated, you have equity in your labor that you're transferring to make a purchase of something that you actually want and feel like you actually need. So that's one thing. They don't have all of the rights that they want. Even in Texas, they in 1401A in the Texas Code of Criminal Procedure, I believe it is, they have no, that's 104B. They have the right to arrest you for anything. Anything. The guy doesn't like the way you part your hair, you're under arrest, you're being taken to jail. But in Part A of that, they have to take you immediately to a magistrate to determine probable cause. And just because they put that Part B in there, okay, they can arrest you. And they also don't have to know what law they're enforcing, but it's the excuse they've given themselves. But all the rest of the rules taken before a magistrate immediately, that's, let's just say real quick. Not 2 or 3 days, not 11 months later, quickly, within a certain time period. That's considered immediate. I think they allow 48 hours for in case, but it's to be immediately. You in Texas never get that examining trial. You in the jail, once you've been put into jail, another little key, the only person that can put you behind bars is a judicial officer, a judge, a magistrate. They're the only ones that can commit you to jail, not a police officer. The mere fact that a police officer put you behind bars is him exercising a jurisdiction which he's not trained for nor competent to hold, which means he never trained to be a judge. He never went and learned the laws that he's enforcing. He's never been certified by any group of people that he is proficient in these laws and obeys them. They just give him the right to dunk your butt in jail, and there you sit. Nobody knows you're in the jail, because at that examining trial, once they find whether they can jail you, bail you, or let you go. That's what the magistrate is for. You have the opportunity, the officer has the opportunity to state his case against you, and you have the opportunity to counter his claims with some of your own to determine whether you're going to jail, whether you're going to be bailed, or whether you're just going home because the officer was wrong. It does happen once in a while. They are wrong. Believe it or not, they are wrong. And we've learned they're wrong every time they make a move, when they take a breath, when they wake up, and when they go to bed, they live their lives wrong. That's another subject.
Right. Well, let's get into then
jurisdiction.
Jurisdiction.
Well, now, they don't have a warrant to arrest you, which is required, and they swore they would. And now the police officer is writing the complaint against you, which would be the citation, or it may be a legitimate complaint against you, appear to be a legitimate complaint against you. But the only thing wrong with that is the police officer has neither capacity to issue the claim nor the standing to bring it into court. And what do I mean by that? To have capacity and standing is the only way you bring a charge into the court. You have to be damaged, which means you had to either violate that police officer's rights, or you had to injure him monetarily, physically, or in some other fashion. But he had to suffer a damage. Well, he's not crippled, he's not blinded, he's not run over, nobody beat him up, nothing happened. He's there witnessing against you, and he doesn't have the right to, because, well, nothing's occurred to him. He doesn't have capacity and standing. Yet he still brings this complaint or this citation to the prosecuting attorney, who takes a look at it, knowing full well he has no capacity and standing. The prosecuting attorney then converts that to an information or an indictment. If it's an indictment, it has to go before the grand jury. So this would be just an information, submits that information that is fictitious and couched in perjury. He brings that to the court. The judge, who is a learned individual, takes a look at it. He can see that there's no capacity, no standing, and that the prosecuting attorney has completed fraud upon the court because there's nothing to write an information about. So the judge takes it and then asks you, how do you plead? They have no legal authority to be asking you anything or anything to be done because the police officer is not a qualified witness. Never can be. And he can't be, and an advocate. That means he can't bring the charge and then witness against you because he brought the charge. He can bring a charge, somebody else has to prosecute you. He can prosecute you if you've injured him. You know, you ran over him or he's damaged. He's injured. Now he's got a claim against you, a real one. But traffic, please. Now, we've already touched on the jurisdiction. When you challenge the jurisdiction, everybody has to understand this. You do not challenge the judge's jurisdiction. Why? We had a little talk about this. If somebody wanted case law, let me give you something a little better. I thought about it. When you issue a complaint to a judge or a magistrate, what are his duties upon receiving that complaint? Or if there's a complaint, no matter how he finds out about it, what happens then, Scott?
Well, he's supposed to reduce it to the information and give it to the foreman of the grand jury to take it to, and the foreman of the grand jury can take it before them to see if they're going to true bill or no bill. In other words, get an indictment or not.
Well, is that not jurisdiction?
Well, that would be the jurisdiction of that proceeding of the court.
Exactly. He does have a job to do, and since he has those duties, he has jurisdiction to complete them. That means he can take a complaint. If the jurisdiction is challenged, it's not the judge's jurisdiction that's being challenged. It's the person issuing the complaint or the prosecuting attorney. That's whose jurisdiction you're challenging because A, they don't have capacity and standing. B, there's no Fourth Amendment warrant. C, wasn't taken immediately before a magistrate for a determination of probable cause. All that boils down to due process violation.
Well, and this is where we're having the immovable object meeting the unstoppable force, because the judges are ruling as a prosecutor from the bench. Therefore, now we're not fighting the prosecution, we're fighting the judge.
Easier target, actually. That's not his job, and if he does it, he's in breach of fiduciary duty, he's in breach of his duty of loyalty, he's in breach of his oath, he's in breach of procedure. He is a referee, an impartial, unbiased referee to make sure that everyone is compliant with the rules of court. It does not give him any ability to tell you what he's going to do to you. The moment he does that, he's tampering with the witness because you have testimony to give. He interfered with that testimony by threatening you. He's in a lot of trouble now.
Well, and that's when it also starts coming into having people go to court with you, because when you, even though it's so funny, because I go to traffic court, I've been several times, and there's a lot of people that accompany people, and if they only knew the power of the third party witness, and if they knew what was being violated and how they could write up complaints as a third party witness, these people could really show the power of to the courts who holds the power, because their power is so much stronger than the person actually complaining. So go ahead and explain the third party witness, everybody, while we got the chance here.
Okay, well, I'll give them a case in point. There was this weirdo that I accompanied to court in a place called Addison, Texas. Okay, and I went in just to go in. I haven't been in court in a long time, and we were called in there, and I sat down, and this other fella, you know him real well, sat down, and within about 20 seconds, I was standing outside the court because I was a potential witness, as what I was accused of by that a fellow that was pretending like he was a judge. So in about 20 seconds, not enough time for anything great to occur, but I had enough of a complaint on that judge to file 3 criminal complaints. I've filed 1. I've got 2 more to file, but what's the hurry? He's in so much hot water now that when they come, they'll be irrelevant. But I filed a complaint to the Judicial Commission and as a third-party witness. And a third party, for anybody that's interested, is somebody that has no connection to the court whatsoever. He doesn't have an action in the court. He's not being acted upon by the court. He's just there as part of his civic duty to check on his employees, see how they're conducting business. Well, in that particular arena, it wasn't good. They were taking a lot of liberties and committing a lot of infractions, easily converted into crimes, like they do to us. So as I saw this in 20 seconds, I have a little bit of experience, sat down, got run out, not a problem. The charges I made, they hurt him. They hurt him more than the charges that you issued on him in a judicial complaint. Why? Because I have nothing to do with that court. I'm somebody off the street, the public, their boss, and acted like it when I wrote him up. Yeah, they threw me out of their court. Big deal. It's going to turn out that he's not going to have a court to throw anybody out of in a short period of time. And I'm looking forward to that. But that's a personal thing. But if everybody could take advantage, everybody's got friends that go with them to court. If that sucker knew how to write and knew what he was looking at, I'll guarantee you that judge would be an unbiased, impartial referee. Guarantee.
Well, and that's a topic for another time. We'll actually address writing and doing things like that to generate paperwork, things like that to kind of give you insight on some of that, putting together timelines. So all this can, because everything basically is a story. Once y'all realize that this is a story unfolding before you, then you'll see that there's a lot of things going on that you just wasn't paying attention to. So getting back to the traffic aspect and court behavior. So I've seen various outcomes in the way paperwork has been submitted. Like I have submitted challenge and subject matter jurisdiction, which they all were outright denied. Then I started turning in some different paperwork and challenging the complaint with a counterclaim. And a counterclaim is basically when the officer made a complaint against me for driving with an invalid license, I turned around and made a counterclaim against him for violating my rights and due process of law. And it effectively come down to arguing the point, how many laws can a cop violate in order to be able to charge you with a crime, or me? So that was the aspect that we're looking at this from, is they don't. Go ahead.
Well, you threw something out there. Now everybody is just dying to find out how many crimes or criminal actions can they make to convert you into a criminal from just an everyday Joe. How many exactly?
Oh, 0. I forgot to say 0. Oh my gosh.
Absolutely. And without that specific number, the entire address was kind of weak.
Oh.
But now it's got some bite to it, because they can't do a thing to make you a criminal. You either are one or you aren't one, and they can't make you one by charging all this stuff that doesn't pertain to you.
Yeah, I was thinking past that. So absolutely, they cannot violate any of your rights in order to be able to charge you with a crime. In fact, it's more specific than that. They took an oath to guarantee that they would uphold your rights, to
Yeah,
make sure that your rights would not be violated. Because what is the essence of government again? Jay, please.
the essence of government is to protect your life and your property, period. Nothing else. No food stamps, no military service, none of that stuff that you're conscripted into on a daily basis to be a good citizen. Their only job is to protect your life and protect your private property. That's what they were initiated for. And that's all.
Right. So now, and we already understood that the judge is supposed to be completely neutral. He's supposed to be a fair, unbiased arbitrator, which he's not. So now back to court behavior and submitting paperwork. So I have submitted various paperwork and then submitted a counterclaim. Well, here around Dallas, it's a large city. I'm sure everybody's aware of. And these courts will flat out run over you no matter what. And the reason I can tell you that how this happens, or how it's supposed to happen, but what actually occurs, these are two different things. So what is happening is when you put in the counterclaim, then you've made a claim against that cop that whatever he says, you're refuting it. Now, according to what the actual time limit is, you're supposed to do this within 30 days. That's why they always want to see you after 30 days after getting the citation, because technically you're in default. Nobody even realizes this. This is an old, antiquated type system that they secretly imply, but they don't really let you know that it's being implied, but it's really being implied. So anyhow, you're supposed to get a counterclaim in within 30 days. If you don't, you can always go nunc pro tunc, which means then is now, so you can always go back. The lawyers are well aware of this fact. Trust me, I've mentioned the term before, and their eyes get wide open and their mouths do. Their eyes get wide open, so do their mouth. So
And why would that be, do you suppose?
because any claim, no matter how long ago, you can call it back and start it all over from the very beginning, saying from this point forward, this is what we're addressing.
Yeah.
And that is where everything on from what we're talking about is being attacked from. We're attacking the whole situation from the very beginning, not from the behind. We're not defending, we're actually asserting our rights. And this is the difference. And this is how everybody has to understand. This is how they flip the script. Because by you not answering the complaint, technically with a counterclaim, you're in default. So if you're in default, no matter what you do, you're already the loser, aka the defendant. So when you go in there with a counterclaim, the counterclaim is supposed to go ahead and stop the proceeding right then, because the civil matter has basically come in over this supposed criminal matter. And if the judge is a neutral arbitrator, then he would stop the proceeding. A buddy of mine down south in Polk County, Texas, he did that. He put a counterclaim in on a traffic ticket when he was coming up, and the judge absolutely said that the criminal proceeding, he stopped the criminal proceeding because of the civil proceeding that was brought before it. So the whole traffic thing stopped, and the criminal side, and they were waiting on the civil proceeding to go ahead. So the judge actually was a neutral arbitrator and did what he did that was correct. And with these judges up here in Dallas, they don't do that. They just steamroll over and say a counterclaim, ha ha, throw that underneath the pile there, and say we're going to just proceed with this criminal proceeding no matter what. So now we run into a problem with, you know, how do we deal with something like this? And when we start running into judges that are so foul and so corrupt and are so biased that their court is, you're not going to get any justice there. You're not even going to get any remote semblance of law being practiced there. So the only way I could do anything was go to federal court and file a federal lawsuit, which was a Title 42. So with the Title 42 brings in the civil action of due process, and that's what this whole thing is being addressed of, is the due process that they violated. Because how many laws can a cop violate to charge you with a crime? Zero.
Zero. Yeah. Now, you've taken them to federal court, but everybody knows that if you take traffic into federal court, they will throw you out before the ink is dry on your documents, on your suit. You're out of there. Federal court will not hear traffic. Is this a traffic case that you've brought to federal court?
Negative.
And how do you differentiate between what it is that you brought and what it is that they're looking for, or what they're looking for to turn?
Because I brought the due process that they, absent the warrant and absent the due process, they outright just violated all my rights in order to charge me with using my rights, asserting my rights. So we have a catch-22 in a constitutional violation here.
You mean they've exceeded
their limitation? They exceeded their limitations, and
now,
by doing so.
Did you ask them if, I mean, sometimes they can do a constitutional violation, but we have found in our studies, in order to have this, they must seek exemptions. So they ask, hey, we got this situation right here. Can the courts give us an exemption on the constitutional limitations that impede us from completing this? I personally, I haven't been doing this forever, but it just seems that way. I have never run into any exemptions ever issued by the courts to law enforcement to violate the limitations heaped upon government. I've never seen them. And yet, in Title V of the U.S. Code, which is government and government employees, catchy name, don't you think? It tells you in Section 706, subsection 2, subsections A, B, C, and D, that in order to do these things, they must have sought and received exemptions, which, when you ask for them, they don't exist. What I'm trying to tell everybody is these people are non-compliant with the laws, the rules, the statutes, the constitutions, the stipulations, and the memos from the bosses upstairs. They don't comply with anything other than, we got to make so much money every week, this week, for the next however long they need to meet a shortfall in the budget. And that comes right from the city manager's desk, if it's that form of government. Big towns, city manager. Small towns, it's generally a mayor and a city council. But they are required to protect your property and your life. That is stated in Hale versus Henkel plainly. It's written in 1906. They've tried to overturn that particular case. The last time I looked, it was 1,800 times since 1906. And they have overturned it 0 times. And that is right now 111 years that it's hasn't been overturned. It is true today, just like it was in 1906. And it specifically states the government's there to protect your life and your private property. It also states you have no duty to the state, period. Now, put that in your pipe and smoke it for a while. Everybody thinks, well, the state said we gotta scratch our butts when they itch. That's all we gotta do. We don't have to pay them any mind because the law already said we don't have to.
Well, speaking of the law and actual driving with an invalid license, which is a charge that I have, which what was the Ted v. Holloway v. State? I believe you have that handy.
It's funny you should mention that. Here's a little document that I have and I've had for a very long time, and I laid it on you when you got that charge in that little town, and I laid it on them too, and they seemed to really appreciate it. But Texas traffic laws, no license required with a question mark. And this comes from the Court of Criminal Appeals of Texas. I'm sure somebody's heard of them. It's the little gang up there in Austin. So the case is Ted Holloway versus the state. It's case number 25-192. It's a Blue Book citation form, 1951, Texas 188. Date decided March the 7th, 1951. Driving motor vehicle while license suspended. Appeal from County Court of Jones County. Penalty fine of $100. The judge was Judge Roger Garrett presiding, and the appellate panel was Judge Woodley, who wrote the decision. Okay. The appellant was convicted and assessed a fine of $100 under an information and a complaint charging that appellant did then and there unlawfully drive and operate a motor vehicle upon the public roadways of the state while his driver's license was suspended. Appellant attacks the sufficiency of the information to charge an offense. Does that sound like a challenge to subject matter jurisdiction?
Mm-hmm.
Okay. The prosecution appears to have been brought under the provisions of Article 6687B of Vernon's Annotated Civil Statutes, commonly referred to as the Texas Driver's License Law, Section 27 thereof, in part providing that no person whose operator's commercial license or chauffeur's license or privilege to operate a motor vehicle in this state has been suspended shall operate a motor vehicle during such suspension. Section 44 of such act provides a punishment for such offense. Now, did you hear what they said? An operator's license, a commercial operator's license, which is now considered a CDL, or a chauffeur's license. All three of those licenses, this is 1951, an operator's license, a commercial operator's license, and a chauffeur's license, or the privilege to operate a motor vehicle in the state has been suspended. Well, that's privilege, but you have a right to travel. And they can't. That's a right. A right cannot be converted into a privilege. That's that word here, privilege to operate a motor vehicle. A right cannot be converted to a privilege and charge a fee for it. Okay? That case is Murdoch versus Pennsylvania. The court said you can't do that. A right is a right, which brings forth a right. Unauthorized practice of law. Can you be charged with that?
Mm-mm.
Why not?
Not an attorney.
Well, the right to practice law is a common law right.
Well, yeah, I'm not. Yeah, it's a common law right. So, and since I'm not an attorney, they couldn't charge me with nothing.
But it's a common law right.
Right.
They cannot convert it to a privilege. and then charge a fee for it. What would the fee be? Oh, your license. The fee for your license, the fee for the application to get your license. All those are fees for the privilege of doing something that would otherwise be illegal. Practicing a right, asserting a right, cannot be construed as illegal. It's a right. Everybody can do it. So the verbiage that they use, it's strictly commercial. Motor vehicle, chauffeur's license. That's why if they don't see you hauling passengers, that would make you a chauffeur, or a commercial operator, or an operator. Both of them are commercial. The operator is used for automobiles, which cannot be construed as motor vehicles. They're automobiles. They're household goods. I mean, part of the necessities of life nowadays. With cities being as large as they are, and if you work across town and it's 60 miles away, it'll take you all day to walk over there. You'll miss that day's work, but you'll be ready for tomorrow's work. But unfortunately, you don't have any place to sleep or eat or shower or even go to the bathroom while you're waiting to go to work. It just doesn't work. Now, let's go to another case. The information against the appellant fails to allege that the appellant had been issued either an operator's, commercial operator's, or chauffeur's license, or that he drove a motor vehicle while such license was suspended. So they charged him with something, but they failed to say that he was any of these specific classes of person. Now there's another case in Hassell, Hassell versus the state, 149 Texas Criminal Code of Procedure, 33, 194 Southwest 2nd edition, page 400, and information alleging that the defendant operated a motor vehicle upon a public highway without a driver's license was held insufficient to charge an offense, since a driver's license is not known to the law. In Barber versus the state, 149 Texas Crim, 18, 191 Southwest 2nd, page 879, a complaint charging the operation of an automobile and failure to display operator's license on demand of a peace officer, not a law enforcement officer, was held insufficient to charge an offense in the absence of an allegation that accused was, on the date of the alleged offense, a licensee.
So we have multiple cases of case law affirming that there is no license in the state of Texas. And
Well,
Ted V. Holloway summed it up perfectly as well.
Well, this one is absolutely perfect, because I mean, they're alleging an offense, and they can't prove that on the day of the date of the allegation that the individual was a licensee, and he had knowledge that he was in commerce. I didn't say business, I said commerce.
Well, that's where we get back to the whole crux of the matter, is they are charging everybody as if they're in commerce.
Well,
misclassifying.
This information being insufficient to charge an offense, the judgment is reversed and the prosecution ordered dismissed. Opinion approved by the court, case resolution reversed and dismissed. So, if you're charged with driving without a license or a suspended license, did they prove or even attempt to prove that you were a licensee at that date and engaged in commerce?
No.
Well, they have no capacity and standing to bring that forward. The cop, and the cop is not a peace officer. He's law enforcement, a LEO. There's two distinct differences. A Leo is bound by his contract, and a peace officer is bound by the Constitution and its limitations.
So the Leo is the policy enforcer, which is something we addressed a
Yes,
minute ago.
exactly. And the peace officer is a constitutional officer that will respect your rights and your life. That's his job. The Leo is there to collect money from you no matter what, because that's deemed to be the gist of his entire life, is there as a revenuer.
Revenue collector.
Revenuer back in the 30s when they were busting all the stills in Appalachia. They were revenuers. Back in those days, they'd come out hunting for alcohol stills, and once in a while somebody'd make it back, but they were plenty of people that never made it back, and the government never has found out what happened to them. They must have
Well,
been
now, so now we can get back to it's when you put in paperwork and back to courts and what is should happen and what doesn't happen. So now when I have put in a counterclaim, so this goes back to subject matter jurisdiction, because once the counterclaim has been established, and I established this fact, give it to the judge. Of course, this judge, he refused to even, they wouldn't even open the folder and look inside it, because they already looked inside it once and said, oh, no, no, no. We can't even address this because we're done. And so, because basically the first sentence had them just done, absent a Fourth Amendment warrant, violating policy and procedure, what authority did you have to stop and arrest me? You know, and they have no answer because they had no warrant. So hence, they have a problem.
But that wait, whoa.
Go ahead.
Go back to in Texas, 1401B.
Mm-hmm.
They can arrest you for anything. Now, can you hear a ka-ching out of that?
Yeah.
Well, it's put in there. It seems like a very bad thing. And then they couple that to, well, the Leo doesn't have to know the law that he's enforcing. He just has to enforce it. Then all the rest of these things, due process things kick in, and it doesn't make any difference what that thing that they put in there for their convenience. They still have to comply with everything else. And that particular clause says they don't have to. So when they don't have to, they really have to. And when you go after them, it's proven to them that they must.
Right. Well, so let's just carry forward here, because we're talking what occurs in court itself. And when you give them this counterclaim, you're presenting a claim against that officer challenging his capacity and standing. So now once you challenge the officer's capacity and standing, the judge is supposed to be a neutral arbitrator sitting up there on the bench, which they're not, because they don't even address the counterclaim, but occasionally they do. So I can't say that not all of them, just the ones around here in Dallas have not. So anyhow, once you challenge the capacity and standing, and you have established that the cop does not have, or LEO, law enforcement officer, whatever you want to call him, does not have the capacity and standing, and you say you have brought charges in your counterclaim, which I have, that he has violated my rights. Now the judge has lost the jurisdiction to hear his case. He's lost the jurisdiction because the guy doesn't have capacity and standing, because it's been proven he's been fraudulent in either by his actions or whatever he's wrote down was fraudulent, no matter what. So he's been disproven. You're You have proven he's been disproven. So the judge has lost jurisdiction over his case, but he has jurisdiction to hear your case now, because the judge always has jurisdiction of his court. He's just trying to figure out who's the plaintiff. And once the plaintiff gets established, now he can address that. So now you can establish yourself as the plaintiff. You just flip the script on the whole ball of wax right then and turned yourself into the plaintiff, got out of the defendant position. Now the judge is supposed to hear your case where you're bringing allegations or claims against this cop, and now this cop is the defendant, and he can get charged and sent up the river. His case is thrown out and dismissed. Boom. Did I miss anything?
No, you're pretty right on there. When you issue that counterclaim, you are, the mere fact that you've issued it with an affidavit. I mean, all your documents are signed under penalty of perjury to be entered into the court. Now, the cop didn't do that. Whenever you see a statement allegedly issued by a cop as told to by a third party, generally the clerk, that's hearsay. That's not a real complaint. They don't have a complaint. You did. Yours is the only evidence in that court. You have an affidavit signed under penalty of perjury. That is evidence.
So go ahead.
It's the only evidence in the case. Everything else is an opinion.
Well, then you're talking about the DA too. Then, when the DA is the one that's prosecuting, he signs, because like the DA signs over there, he'll sign that he's the one that's prosecuting the case, like he is the witness. He was never the witness, but he's assuming it.
That's exactly, and that right there, his testimony is hearsay and an opinion. And all attorneys, whatever they say or write, are merely opinions that carry no weight, and they never rise to the level of evidence. Now, what do we just call evidence? That affidavit that you wrote? All your documents are signed under penalty of perjury and to submit them into the court? Well, they don't have that. Just you. The only actual case is yours.
Well, because they're trying to bring the state in, and the state can never be as a witness to testify against you. But that's where we have the judges that are not, that they're ruling against everybody. And this is the problem.
Well, they rule against them. And if they're wrong, well, they have a commission that checks up on them. And when you write the commission, they'll generally tell you, well, we don't find anything wrong with this. There's nothing to see here. Move along. And that's the letter you get back. But periodically you get a letter that, well, they respond to the complaints that you issued against their beloved judicial officers. And they count. I mean, all these judges are one day hoping to, or aspiring to sit on the Supreme Court. And, well, if you put a few extra lines on their resume and they're not conducive to a high career, where they are, if they're lucky to remain there after you finished with them, and the due process lawsuit, they frown on that quite a bit. I don't know if you knew that or not, but due process is something, well, they get real touchy about. So,
well, speaking of how the reactions have been through this whole learning curve, we'll just call it that, is the few times that I was in there, well, a few times seems like a many, but every time I was going there before, I was pretty well treated, you know, like a dirt ball. And now when I have made all these claims against the whole county of Rockwall, Texas, and how they've illegally have arrested me, not just once, but twice, that, yeah, this is going to be brought out. And so far, the last few times I've gone in there, I am the very first one in and out. It is like I am not even supposed to be there, which I don't want to be there. All they had to do was leave me alone. I even told them, just leave me alone, just dismiss this and leave me alone. But they won't,
They
because
can't.
it's all, well, they're greedy. And
Yeah. And they've also made a judicial determination to proceed, and they cannot back up. So all they can do is full steam ahead into a real solid brick wall, or in this case, a real solid rock wall.
no pun intended.
No, of course not. Of course not. But this is what since they made the determination and they cannot retreat. It's like the proverbial rattlesnake going through chicken wire fence. They can get their head through. But once they get to where the fat part of the body is, beyond the neck, they can't go forward, and by God, they can't go backwards. They got no reverse. And that's where you'll find the body of that snake when it eventually passes on. And that's exactly where you find the courts when you take them into federal court and sue them on due process. They can't back up and they cannot go forward. They're just there.
Yeah, and another thing is, because basically the way the whole claim is structured, it's pointing that everybody in this whole thing is in criminal conspiracy, from the clerks to the judges to the county judges to the commissioners on the court. They're all complicit.
That's the term I wanted you to come up with. Yes, they're all complicit. This is a money-making operation. Of course they're all in it. What's the matter? You don't expect them to lose money, do you?
Well, and that's where we have a problem. And
well, no. Well, no, you're correct in that. That's where we have had a problem. But now the problem doesn't quite seem as big a problem as it used to be. The lights are turned on, and all the cockroaches are scurrying for cover now, aren't they?
well, of course. And this is a beautiful thing. So, and as more people start becoming aware of what's going on, and how to address it, and using the law the way it was supposed to be used, and now everybody has to pay attention.
Well, that would tickle me. You have no idea. If everybody were to pay attention for just a little short period of time, and there'd be a flurry of these things hitting traffic court all at one time, there'd be no more. They wouldn't have time to do tickets and the roadside harassment and all this. They'd be too busy defending themselves. Now, that's exactly where you want them. You already know that the defendant is the loser. So why not make them the losers? All you got to do is answer their complaint with a counterclaim, claiming all that they did against the law, and you've reversed the see, in this case, you are the negative pole and they're the positive, because they're law and they're law enforcement, allegedly. And when you take and change that around to you're standing right behind them, accusing them of breaking all these laws, you might be able to get away with breaking the laws because, well, technically you don't know them. But they, on the other hand, are sworn to uphold. They have obligations. They have duties. They have the duty of loyalty. They have the duty of the fiduciary duty. They've already promised to do all these things and take care of you. That's a fiduciary duty, take care of you. And here is definite proof that they were lying out their asses.
Well, that's why they have a $1.1 million lawsuit on Rockwall, and Addison has a $3.5 million lawsuit on them for them smashing out my window. If y'all haven't seen it, you can just Google Addison, Texas cop smashing out window, and it's #1 It's had over 2 million views. So they have theirs. Now, speaking of winning and beating courts, this comes right on into Lake Dallas. So this is another traffic court where I was pulled over for running a stop sign or not coming to a complete stop, whatever you want to say. It was a really dumb little intersection. But anyhow, so the cop pulls me over, doesn't even have his video camera on me, so he has no video proof. And then, the silly DA is going to show this, and she shows it to me, and she goes, "You want to see the video of it?" And I was like, "Sure, why not?" Shows me the video, and there has no proof. I said, "There's absolutely no proof." She goes, "You want to see any more?" I was like, "No."
What for?
Yeah. We're done.
No cartoons. I don't want to see no more.
Yeah, so anyhow, they decided to go ahead and proceed. They were just going to go ahead and go on and on. I told them, so I put in all the subject matter jurisdiction, challenge this, challenge that, challenge, blah, 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 blah. And then, so basically, I had to go to court. Well, that was a court after I turned in the subject matter jurisdiction and all that stuff. The judge died. And so they had to get a new one, which they did. And she's probably not happy she got that little assignment afterwards because I won in that court. And so how it basically occurred, even though I had all the subject matter jurisdiction, they just totally railroaded that. They weren't going to hear none of that shit. Well, in fact, they never even got to the damn subject matter jurisdiction motion. I went there 4 times before. Well, on the 3rd time I went to Lake Dallas, they wouldn't let me see the judge. Said I didn't sign this little paperwork. I was 2 minutes late. I couldn't see the judge. Kicked me out of court. So I called 911 on the courthouse. Not just once, but twice. Because they didn't come after an hour. And so an hour later, I called 911 again. I had 2 people that were witnesses too. They were sitting there going, "I can't believe you're going to call the cops." I said, "Yeah, I already called them once. Watch this." Boom, call them again. Well, she gets on to the clerk in there, and they just, "Yeah, go ahead. We're going to let you see the judge now," because they didn't want to bring a sheriff out because I was going to file criminal complaints right there. I said, "Bring me a sheriff so I can file criminal complaints on the bailiff here for kicking me out of court." So anyhow, they let me in and said it was a reset. So, and then the next time I went, I actually took a friend with me, and that's when I already mailed them a counterclaim. So I'd mailed them a counterclaim this time. Every time I'm doing something, I'm getting a different reaction. So we go in there before the counterclaim, and I tell the judge I'm only here. Well, I don't address him as a judge. I never address him as a judge. I just tell the lady, I said, "Ma'am, I'm here for this counterclaim. That's the only reason I'm here." And it totally blew her mind, and she's like, "Okay, well, denied and reset." So she reset it again. So now I got to come back again. Well, this was the last time I went back. This is where I won. But they had to, the DA, and this is after I've already bar grieved the city attorney a couple of times. I've bar grieved the judge, or the judicial conducts to the judge for having me kicked out of court with her bailiff. I mean, I was bar grieving and judicial conning everybody back to the Stone Age. So now I'm going in there, and they know I'm coming full bear to fight them. It don't matter. Well, they sent me a letter saying they wanted a motion in limine saying that they wanted the cop not to be able to present any evidence. They didn't want the cop to talk because he was on the Brady list. We'll come to find out the Brady list is a do not support list. And the do not support list means that these cops, LEOs, cannot be heard in an appellate court. So therefore, this is how it occurs. So you can go to court in the municipal court and be tried and convicted and appeal that case to the appeals court. Once it goes to the appeals court, the judge is going to dismiss it because the cop is not a credible witness. He's on a do not support list. So what had happened when they called me in to see the judge, I get up before the judge, and they're like, "Did I get that motion in limine?" And I handed them a piece of paper. I said, "I object, and here's my motion for objection or whatever I've submitted, and I said, your cop is not a credible witness, can't be heard on an appeal in an appellate case. And the DA looks over at me and she goes, are you going to appeal this case? I said, well, not right now. I said, but if the judge is going to rule against me, and if you're going to rule against me, and then we go to trial and it rules against me, then I'm going to appeal this case. It's going to go to the appeals judge, and he's going to kick this case out and dismiss it because your officer is not a credible witness and he is on a do not support list. DA looks immediately at the judge and says, I move to dismiss this case in the interest of justice. Boom.
Yeah, when you got them, when you have their feet nailed to the floor, then you're going to get due process. Then you're going to get everything you're supposed to get. When they're looking at a prison sentence, everything gets kosher.
Right. So what here's the ramifications that a lot of people don't realize. First off, there's a Brady list out there, and the Brady list is held by the DAs. The DAs have a list of all the cops within the surrounding counties in their district that are not credible witnesses. So if these cops are out there writing these citations and they're on the Brady list, they're automatically dismissed. They're not a credible witness. Now, here is the other side to this coin that nobody really gets. The conviction rate for traffic is 99.6%. Okay? Everybody's guilty. Now, when you go in there and actually beat one, these people really have a problem. They know they have a problem. You just don't realize they have a problem like this because they violated every right you had, violated due process, did every freaking thing wrong under the sun. Now, if you bring a lawsuit out against them, you're going to win because you already beat their ticket, the whole premise of their case to start with. So I have a perfect lawsuit against the city of Lake Dallas for $5 million.
What I wanted, you noticed you were talking about the Brady list and prosecuting attorney, the DA, the county, city attorney, whoever is doing this. The mere fact that they have that Brady list, they have it, and they know of it, and yet the rules require that they give you exculpatory evidence, and they didn't, and they don't. That's a criminal charge on that DA. No attorney general job for them.
Well, regardless of the fact.
Well, that's a charge. Yeah, but they're charging you for bullshit. But this is not bullshit. That DA with that slick little sharp practice, they deny you exculpatory evidence. They can't do that by their own rules. So now you not only have another bar grievance, you have an actual criminal charge on that DA.
Well, and here's the thing, because once you bring this into a federal, that's where I haven't started filing federal criminal charges yet, which will be coming. So, but I haven't, so far, the federal cases are in a kind of like a limbo because at this recording, it's about like 15, 17 days before Trump is actually in office. So I'm actually thinking until after Trump is actually officially in office, then I might start hearing something from the federal courts on some of these suits, because Rockwell is already 85, 90 days default from just not answering what I submitted to him, not to mention the counterclaim that's probably like 4 months default. So, I mean, they have no ability to answer. No. It's just now we're bringing light to all this criminality that's going on and showing everybody out here how to address it. And this is what's going to help people out. So, besides, well, yeah, but go ahead.
We're just talking about traffic court, but these same things, let's say you're out driving your car and you're burning a doobie and you get stopped. They smelled marijuana. Okay? You can use the same procedure, bust up that stuff. And there's more things. We'll be discussing marijuana, what it is and what it isn't, and what is legal. I mean, there's weed that you can smoke legally today, right now. It's in the books, but that's another story.
Yeah, we'll have to get to that one. That's another episode where weed, there's a legal definition between weed and marijuana, and this is something everybody should know. So just a short synopsis, weed is not a legal term. Marijuana is a legal term. And most of y'all that are smoking some weed, y'all ain't smoking the legal definition because that would be sativa L. Most of y'all are smoking indica, which is the bud that everybody gets around here. So if you're smoking indica, you're smoking weed. Make it a clear definition. It don't matter if you're sitting on a bale of that shit. You're smoking weed. You smoke weed. It's not marijuana. And
it's not mentioned in the code. It is therefore excluded from the code. Well, marijuana is mentioned, is included, and by legal terms, what is included excludes everything else. So cannabis sativa L is included, but cannabis indica, cannabis ruderalis, and all these other gigantea, cannabis americana, they're not in the Texas code, so therefore they are legal.
Well, and that's going to be something that we'll address and make more people aware of. And hopefully we'll just have people start growing that shit right out in their front yards. And if enough people do it, they ain't going to be able to stop it. It's a damn weed. The only reason it's illegal is because people are making money off of it anyway by putting people in jail. It's a bunch of shit anyway. Should be legal.
It is legal.
It is legal, but nobody knows about it. That's the problem.
But they will soon. Just a teaser. It's been legal for sure since 1986. All of it. We'll just leave it at that.
Right. Like I say, that's going to be another episode. So basically, for the traffic thing, pretty much addressed all of it, the court's actions. You're going to get a lot of various actions. Most of it is going to be railroading. You can pretty much expect everything as a consistent railroad. Once you go and file a civil lawsuit, then you really get their attention, because like my case over in Rockwall, there was no way in hell I was going to get any kind of fair hearing. I even submitted criminal complaints to the county court at law judge against a municipal judge who kindly slid them back across the desk to me saying, oh no, you'll have to file these in a civil suit here in our court. And when he said our court and just sit there and grin, handed me back those 3 criminal complaints, I just sat there and smiled and said, that's another charge. You just refused to take 3 criminal complaints from a competent witness. Those are charges against you, magistrate, because the duty of a magistrate is bound to take any criminal complaint from a credible witness, hand them to the DA that they can reduce it down to an information, give it to the foreman of a grand jury so he can seek an indictment or no bill, which he did not do. He failed to do his duties as a magistrate. Shielding prosecution, maybe? Yes. So these are some of the things that you people will just have to be aware of, that it's a arduous learning curve, which you should endeavor, because once you do know what your powers are and you're able to start helping others, it's going to be a life-changing thing. Not only that, but the white hats in the government are actually waiting for people like you to stand up, because they can't do it all alone. I can't do it all alone, but I guarantee you keep putting it out there. It's like the 100 monkey thing. Everybody starts learning, and the learning curve is going to be huge.
Now, Scott,
Go ahead.
Scott,
Go ahead.
yeah, you've talked about Lake Dallas and Addison and Rockwall and what did I leave out?
Oh,
Mesquite. You haven't talked about Mesquite, but I want you to talk about what happened in East Tawakoni at the lake
oh
and
yeah.
the difference.
Right. Well, there has been one noticeable difference, and this is also with a smaller town a little further out away from Dallas. So this is Rains County. Everything that I've been dicking around here has been Dallas, Mesquite counties, Denton County, and I've done a little work over in Kaufman County. So, but in Rains County, I went out to go visit some grumpy old codger one day, and he was kindly told me to get the hell out of his place and go away, never come back. I'm just kidding, y'all. I went to go see Jay. We was hanging out, talking about a bunch of law, and I got ready to leave. It's about dusk, and so I was coming back home, just turned on my headlights, and I was about to cross Lake Tawakoni when the lights came. Well, all of a sudden, then I got pulled over by this cop. What was his name again?
Lieutenant Patterson.
Ah, Lieutenant Patterson. Yeah, how can I forget? I just have so many on my brain. But anyhow, so Lieutenant Patterson kindly gives me a free ride to jail after I informed him many times that I'm just traveling. And he informed me you have the right to travel on your feet wherever you go. Oh, and you have been charged, you have been convicted of driving with an invalid license like 4 times. I said, no, I've been charged with it. I haven't been found guilty of anything yet, you know? And he said, well, you're going to jail. So basically, he took me to jail, spent overnight in jail, got bonded out, and immediately turned in a counterclaim that in about 2 days later. And remember when I was telling y'all about the 30 days and turning in a rebuttal to their claim within 30 days? Well, I turned in this counterclaim within 30 days, rebutted it, and I have not heard a word. Now, here's another thing that occurred. When he took me to jail, I refused to sign anything. I told him I wasn't even supposed to be here. I'm a traveler, blah, 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 blah. He's violated my rights, blah, blah, blah. Sit down, shut up. I refused to sign anything. The little jailer that was in there finally grabbed me off the bench because they didn't know what to do with me. They sat around for about 2 to 3 hours, I guess, or at least a couple hours. They couldn't figure out what to do with me. And it's like, you need to sign. I was like, I'm not signing nothing. They didn't know what to do. So eventually they grabbed me off the bench and told me I was going to do my fingerprints. I did my fingerprints. And I told him, no, I resist. I resist. You're going to have to force me to do it. And so when he started calling in the goon squad and all these other big old lard ass country boys, they come in there. I said, okay, okay, okay. I said, you know, I do not consent and all this other shit, but go ahead. So he took my fingerprints and they said, you got to sign it. I said, I told you I'm not signing anything. And he throws that card across the jail. They don't know what to do. So I'm going in, and now they put me in the tank where all the hardened criminals are. And these hardened criminals are guys that got charged with um, not paying child support or some shit, you know.
Oh my goodness, the bad ones.
Yeah, they were the vicious hardened criminals of the world.
I'm sorry
So
you had to go through that.
yeah, so they even asked me, they go, why are you in this side? How come you're not over with people that are, you know, with the traffic people? I said, you mean there's people in here for traffic that are in jail? And they're like, oh yeah, they're over there on the other side. Blah, blah, blah. And I said, well, I refuse to sign anything. They go, what? And I was like, yeah, I'm not signing jack shit. They go, oh wow, I guess that's why you're here. We never heard of that. I said, yeah, nobody has. They didn't either. So anyhow, I got bonded out the next morning, the magistrate judge, I get to go before him, and he sits there and he says da 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 da, and he goes, you understand? And he was like, hands me something to sign. I said, I told everybody else, I am not signing anything. I'm just a traveler. And the judge says, take him back to the just take him back. He didn't know what to do with me. But they have not sent me any paperwork for a court date at all, and it's been 8 months now, according to the the lady that I call into about my bail bond. She says, "Oh, we move really slow out here. You know, it could be up to a year." She goes, "But you know, it's really funny." She goes, "With yours, you know, it's kind of yours is kind of funny because the things that you got, her bail bondsman is tied in with the same bail bondsman with Rockwall. So I got the two bail bondsmen doing the same different counties." And she goes, "Yeah, Rockwall usually goes really, really fast." I said, "Yeah, they're kind of going a little bit slower now." She goes, "Yeah." She goes, "Yours is kind of really slow." She goes, "Yours is pretty interesting. I kind of want to keep up with yours." 'Cause I kind of filled her in a little bit. And anyway, and I said, "Well, what about Rains County here? That's where yours is. I mean, what's going on?" She goes, "Well, if nothing happens within 2 years, I get to file in for to have it dismissed." I said, "For want of prosecution?" She goes, "Exactly." I said, "Well, guess we'll just see if they do anything because I'll be coming for them next."
Yeah, they've already made the legal determinations. They can't back up. You went to jail for what? Traveling?
Mm-hmm.
Interesting. I wonder how they're going to explain all that.
Well, they get a chance. Patterson, oh yeah, and you know, he likes to rub it. Everybody knows about the Addison case because the Addison case is the one that kicked it off where I got my windows smashed and refused to just kowtow down. And so that my buddy out there, Shake, however you say it, um, yeah, he's got some splaining to do.
Uh-huh. Yeah,
Because he
yeah.
actually admitted, I asked him, "Do you have a warrant?" "No." "Is this a custodial stop?" "No." "Well, ain't much for us to talk about." "Well, you were speeding." "I'm not a commercial driver." Uh, "Show me your license or smash your window."
That's assuming you had one, and it never was required that you show that you were a licensee. You may have been at one time, and you have every right to prepare yourself in case you decide to avail yourself of the commercial side of all this. You have that right. But if you're not doing that, well, then you're in your automobile carrying on the necessities of life. And that's not a commercial deal, so they don't have any place to pigeonhole that category. It's either commerce or it's not commerce. And there is no not commerce because they're a hammer, so everything's a nail.
No.
Until you
And
bring
here
in
lies,
a
yeah, here
reckoner.
lies the problem. We got to delineate who is what. And
Well,
once we,
they won't accept your delineations. You offered to tell them. You ask them to save themselves a lot of grief by dismissing the case, and they already have that case bonded. They've already received the money for it. They need you to sign for all that stuff so they can get paid, including the jail. Everything, you signature that you applied for it, you begged them for it, you submitted to it. It's your idea, and you wouldn't sign. Hmm. Hmm. That puts a kink in their skivvies.
like a lot of this does. So,
All of
but
this
that's,
does.
well, sure. I mean, because like I say, now I've got to go to court on the 12th this month here in January. I'm pretty sure it's going to be in and out so fast because effectively I have called the judge and the DA criminals, and I filed bar grievances and judicial conducts along
What did
with,
you? Yeah, I wanted to ask you. Tell everybody the little treat that you included to the Judicial Commission to complain about these several judges. That little thing that a couple of things you added at the end as a holiday cheer or whatever, and explain exactly why once again.
well, I can start with Mesquite. Judge Crane over in Mesquite should have a Merry Christmas along with all his other complaints filed, because I appealed his judgment and he refused to appeal it. So therefore I submitted an appeal to the Fifth Circuit Court of Appeals here in Dallas, which they kindly said submit all the records, which I kindly did. Now, previously, when I had trial with Judge Crane, it was a bench trial, I had submitted a counterclaim and also attached a criminal complaint against the mayor because I had filed a FOIA request for the 911 tapes for this cop. Um, his name will come soon enough. Had suggested I could get shot in the head for presenting a right to travel document. Well, anyhow, I just wanted a 911 tape. Well, I couldn't get that, so I called the mayor a criminal and using the Quislings to do all that. Well, I attached a criminal complaint to all that crap, and when we got to court, I said I have some documents I want to submit. Well, the supposed judge wouldn't let me submit anything. He said, "No, you should have submitted everything already." I said, "Okay, well, there's one that's already submitted. Then it's a criminal complaint." Well, he opened that thing up and started reading it, and he came unglued. This was this is all on tape too. It's on the internet too now. So anyhow, he thought I was calling him a quisling, and I told him I wasn't calling him a quisling. And he said, "Are you calling this court a quisling?" I said, "No, I'm not calling this court a quisling." "Who are you calling a quisling?" I said, "I'm calling the chief of police a quisling because the mayor uh, uh, because he refused to answer my FOIA request, and mayor's letting it all happen as a criminal enterprise." I didn't say all that. I just said shortly what I said. Well, anyhow, he just threw that away and dismissed it. But when I submitted my appeal to the appellate case, all that paperwork gets to go. Plus, I submitted three more criminal complaints, and these were going straight to the magistrates that are going to read over all this appeal documents. Now, here's the thing. Once I sent these criminal complaints along with all the information of the appeals, those magistrates, once they look at it and they see a criminal complaint, they are duty bound to take a criminal complaint, reduce it to an information, give it to a prosecutor so he can give it to a grand foreman and seek an indictment. They have a problem because these magistrates are kind of in a little bit of a trap there. They have to do something with it. And if they do not do anything with it, then technically that's shielding prosecution. They can have criminal complaints brought upon them and submitted to a higher judge. So it turns into a real uh, tar baby, as so affectionately called by some people. So anyhow, that was one of the aspects. What was the other one you were referring to? You there? You just left me hanging? I'm going to be talking?
No, I'm here. I just had it muted because you were talking.
I know.
And um, what you have there, what I'm talking about is what you did with the Judicial Commission. And there are a couple of magistrates on that commission, and the rest are what, lawyers, civilians? I don't know what they are, but there are two magistrates on that board. And the criminal complaints that you added to the judicial complaint was seen by these magistrates, different magistrates, but nonetheless magistrates with the same duty when they find out of a crime being committed.
Well, that's true. And another thing is I had an actual conversation with this Texas State Judicial Commission head investigator or something
Yeah,
about
that's unusual in itself. Nobody talks to those people. They just get a slip of paper saying, "Yeah, we looked at your stuff. It's bullshit. Move along."
yeah, I didn't get that. Actually, I had a 40-minute conversation with that man, and it was very, it, man, I got a lot of information, and here's the gist of it for y'all, that the Judicial Commission receives about 1,000 complaints a month on various judges. Well, these judges um, have leeway in their rulings and judicial review, so to speak, but they have absolutely no immunity from violating any of your rights. And that's where people get mixed up or conflate the two issues, is probably a better way, thinking that they're going to write a complaint against a judge and it's going to get any type of remedy whatsoever. Now, I do know that this has worked because about 3 months ago, I heard on the radio an appellate judge got removed from his position by the Judicial Review Board, and sure enough, came home and looked it up, and some bitch was damn sure scraped off the bench like a piece of shit. Oh, dried up piece of shit. They just scraped that piece of shit right off the bench. It was cool, and they said he was a real asshole too, and a drunk. Go figure. So, but anyhow, um, anyway, so these. The judicial review guy, when I sat there and was talking to him, he said, here's the main problems that a lot of people run into. First off, if you're going to make a complaint, you can't address their judicial review or anything like that. You can only address their violating your constitutional rights. Most complaints that are submitted to the Judicial Review Board, 50% are thrown out automatically, and 80% of those are written by lawyers or attorneys. There are no lawyers, they're all attorneys. Okay, so all these attorneys are going in there just bitching about the wrong damn thing because they either knowingly or willingly, or I don't know what they're doing, or just charging you to make money, showing you that they're doing something when they, oh, if they don't know, they should have picked up the phone and asked. I don't know how I got the information, and I'm, not learned counsel. But anyway, so they automatically dismiss 50% of them, and the other 50% will go before two groups, and one was the investigators unit and one was the attorneys unit. And out of those, half of those will actually get submitted to seek prosecution. So, well, effectively, it's like half of those get dismissed, and then out of those, they actually seek remedy against those. It turns out it's like 100 out of every 1,000 or something that will have any action be brought against. And you won't know about the action unless they get removed from the bench, and then you know about their actions or what occurred from the review board. So far, I've had three of them write back wanting me to release anonymity, because when I first did them, I signed for anonymity, and they wanted me to release anonymity so that they can notify them that they were going to go ahead and seek action. So I wrote up some pretty damning complaints that got a lot of traction, I guess.
Yeah, to get a different response, you had to do something different.
Right. So that's what occurred, and basically these criminal complaints are just a small timeline. They're one-page complaints. I mean, it's not elaborate. Just make a, tell the little bit of a pretext of the story that occurred, what violation occurred, and what are the ramifications and actions occurred because of that. There's my complaint. Boom, send it right on in. And yeah, I'm going to see. And here's another thing. And in the Rockwall case, I'm actually a third-party witness in my own case. Now, we discussed third-party witness earlier. Well, that's just you sitting out in the bench. You're just an idle person. You have no bearing on the case whatsoever. But I was brought before a judge, sitting there answering questions, and then all of a sudden, immediately turned into a third-party witness, like a person standing on the side of the road. And a lot of people would like to know how that occurred. Well, what had happened is I had a friend that came to court with me, and he was sitting out in the gallery, and I was sitting there talking to the judge, talking about criminal complaints about a municipal court judge and res judicata and a couple other things. And this DA started getting really super flustered, looks out into the gallery, points over to my buddy, says he's filming in the gallery and his camera needs to be taken and seized and brought up to before the judge. So now the judge looks over at him and says, "Oh, you're going to be held in contempt of court." And the DA says, "We need his phone." And the judge says, orders the bailiff to grab his phone. Now the bailiff's walking over there, grabs him, drags him up out of the gallery, seizes his phone, and brings it over to him and another bailiff. And I'm standing there watching this the whole time. Now, after they get done looking through his phone and didn't find any recordings, they're standing there with a little bit of egg on their face because they're trying to get my buddy thrown in jail in contempt of court because I'm sitting there getting this DA flustered and he's all wound up like an 8-day clock. Well, they had nothing, so the judge looks back over at me. He says, "I need you to go ahead and sign for this court date." I told him I didn't consent. He said, "If you don't consent, be like nothing happened and a warrant goes for your arrest." I said, "Under duress, I'll sign." Signed it. We both walked out so we could have another day. Just didn't want nobody to go to jail, because they were just so willing to throw anybody in jail for any damn thing.
Yeah. Yeah. Show their power.
Well, the last 3 times my friend and I have been over there, we got a little bit more respect out of them. So it's been in and out very, very quick, especially the last 2 times. In fact, the last time there, they looked like they were just handing out just resets for everybody that I saw. And I was in and out so fast, people were still walking in while I was leaving.
Hadn't settled down yet, huh?
Oh, literally, they were still walking in, getting off. When I went to the elevator, people were still getting off the elevator, coming in. I'm leaving.
That's respect.
They don't want to talk to me because they have a civil lawsuit going, knowing they have 88 more charges that can come right on down the pipe.
That must make for a happy holiday season. Finally.
Yeah, so they've had plenty of reason to cheer, them and Addison. They're over there cheering. And then when I went over there and beat Lake Dallas at the 1st of December of 16, now I have a lawsuit just ready and waiting for them because they knowingly and willingly put an officer out there on the street to generate revenue writing tickets that was on a Brady list that was not a competent witness. Shouldn't even been out there.
Kind of really makes them look bad, don't it?
For some old dumbass redneck that don't know shit. Amazing what happens if you start asserting your fucking rights.
That's been my contention for years. And here is the opportunity to show everybody how it's supposed to work. You worked it. You're not having the same, you had the same response. You worked through it, and now they're in so much trouble that they can look back now and say, you know, when that guy asked us to dismiss this, if he ever asks again, we're going to do it, just for safety's sake. But it's highly doubtful that you'll see the inside of that courtroom or any other for a long, long time, unless you initiate the proceedings, because they're scared of you now. They have respect for you now, which they don't have for anybody until you knock them around for a while. Then they get that, they get it. You're not the guy that they need to be messing with, because you're going to terminate their job description and them in it.
Well, Garland, fortunately, has garnered the respect quite a while back and decided to leave me alone. And that's, you know, where I live, grew up, graduated from. This is my hometown. This is my home state, born and raised, Dallas, Texan, born in Dallas. So I've seen this place what it used to be compared to what it is now, and I don't like this shit. So it's time to stand up and say, fuck no, I ain't taking this shit no more, and everybody else needs to do the same. And when a few people do, you see, because I don't have tags or inspections or front license plate on my car. The only reason I have a rear one on is just for grins right now, so that they can read it and decide if they really want to pull me over. You were riding around with me when a cop got behind me the other day. You tell them.
Well, he followed us a good piece, and we swapped lanes. He swapped lanes, and then when we went straight on and then turned into some business, at that point he'd already gotten the information with all the red flags. He just continued in a northerly fashion. He was having a wonderful ride. Didn't have time to bother with you or me or, well, for that matter, anybody else. He was busy getting away from there.
You know what? I bet you when they pop something like that up and it shows all these kind of red flags, it makes them really start looking at all these other cars too, when they start thinking about popping them up on their little radar too. I wonder if this one's got these tags too.
We'll never know until we train those people, and then we'll know for sure.
Well, there's always a learning curve for everybody.
Yeah. And I think we have bent this one into a complete and utter donut. And I think we ought to leave this alone for now and plan the next assault.
I agree. This has been an excellent podcast. I appreciate you weighing in on this. And this has been Snafu Radio. And Jay, we hope y'all have a good radio or a good day. I don't know what I was thinking there. But you got anything else you want to say?
I just want to say thank you for anybody that listens, and I want to double that thank you for anybody that takes an interest in it. All we can do is help you. We don't want to hurt you. We just want you to be one of us and leave the cops in the dirt, or at least when they run your plates, they have other things that they really need to do.
Agreed. Well, with that, I think we'll end this, and that's Snafu out.
Thanks, folks.